When you visit the doctor, you are asked to sign a stack of forms, but you may be signing away an important right without realizing it. I-Team investigator Michael George exposes a growing practice in the medical industry that its critics say is hurting some patients.
I gotta hold myself, and then I gotta come back up.
This is how Jessica Sapp learned to walk normally again.
Physical therapy works miracles.
For 2 years, 21-year-old Jessica says she suffered from a serious infection after having surgery on her injured knee. One surgeon noted in this report the infection was connected to sutures from her first knee operation.
He removed an actual wire, like a wad of stitches and wire from my knee.
Jessica blames her previous surgeon for causing the infection.
I was livid, absolutely livid. I tried to sue him. I went to 2 lawyers, and they told me I didn't have a claim.
J. Steele Olmsted is one of the lawyers who said he couldn't help Jessica. He says it was because she had signed a document that more and more doctors are requiring from their patients, called a binding arbitration agreement.
I cannot do anything with an arbitration agreement. It ties my hands. I cannot get that young lady and her very badly injured knee in front of a jury.
Arbitration means a patient gives up the right to a jury trial. So if there's a malpractice claim, the case is decided by arbitrators, chosen by both sides. Many doctors use arbitration, and most of them wouldn't agree to speak with us about the practice. But Women's Care Florida did. They manage a group of local OB/GYN clinics, and they show all of their new patients this video.
Through arbitration, patients and physicians both benefit because they are able to more promptly resolve malpractice claims and with less expense to all parties.
But malpractice lawyers claim, unlike Women's Care Florida, many doctors don't explain to patients they're signing away their rights to a jury trial. Olmsted argues arbitrators typically side with doctors, not patients.
Is arbitration fair? Absolutely not. It's a one-sided agreement.
USF professor and health law expert Dr. Jay Wolfson says he's seen no evidence arbitration favors one side over the other. In some cases, he says, it can be more fair than a jury trial.
It tends to be more factual, legal, as opposed to emotional.
The medical community claims arbitration is necessary because frivolous malpractice suits are running out of control, sometimes taking 5 years or even more to reach an outcome.
Doctors want patients to be compensated if they deserve to be compensated, but they don't want the process to go on year in and year out with all of the stresses that they have on their practice, their personal savings.
Jessica Sapp says she no longer wants to take her doctor to court, but she wishes someone told her that she'd already given up the right.
I don't want to have that right taken from me. That is my right. I have the right to sue if something goes wrong.
I'm I-Team investigator Michael George, ABC Action News.
And the important thing for patients is to know what you are signing. Read the documents at your doctor's office carefully. And if you're not comfortable signing an arbitration agreement, there are many doctors who don't require it.